got not just you as our audience, of course, we've got hundreds of people who are going to be watching this online. So let's us here bear that in mind, that it's actually a pretty large audience altogether for this symposium. It's what in our social context of the law series. So I hope some of you saw the standoff between Lord Neuberger and Lord Faulkner over English judges continuing to sit in the Court of Final Appeal in Hong Kong. Tonight, we've got a very different question. It's the case for anonymity in civil proceedings and in social media generally. It's not always a bad thing, anonymity. Some of us will well remember the admonition of Captain Mannering, "Don't tell him your name, Pike." So anonymity for some purposes is perceived to be a good thing. Getting a little more serious about war, I was brought up in Jersey, and of course that was occupied by Germany during the Second World War. There's a fascinating museum in Jersey about the occupation. And one of the rather chilling exhibits is the letters that were written by some of the islanders to the German authorities, basically ratting on their neighbors, saying, and I anonymize the name, "You should know that Mrs. Voisin has a radio in her loft upstairs." And there would then be a search of the house. Mrs. Voisin was carted off to Ravensbrück and never seen again. Now, letters like that were written anonymously, of course, but there were checks on their use or abuse. After all, it took an awful lot for Jersey, with the small society it was, for somebody to go out and post a letter to the Germans, and they could have been caught in the act. What we've seen much more recently in modern times is an explosion in anonymous communications, many of them completely undetectable. So some media platforms, you don't really have to give any details. Once you sign up, you will remain undiscoverable. And that leads people to, for example, troll those unfortunate Euro 2020 footballers for missing their goals. TripAdvisor and things like that, these online platforms, are often trolled by people who will bring down businesses with their vicious comments. So we've seen it take many, many different forms. And the question is, for tonight's debate, whether that's a good thing, whether any good aspects of anonymity that should continue to be protected, whether it's practical to try and do away with anonymity, matters of that sort. And tonight, who better to debate this topic than our three speakers, starting with Andrew Caldecott, Queen's Counsel from 5 Raymond Buildings. Andrew regularly advises and acts for broadcasters and publishing houses, corporations and celebrities, as well as government departments and ministers in the United Kingdom and various foreign jurisdictions. He regularly chairs or contributes to leading media law conferences. He appeared for the BBC in the Hutton Inquiry and for The Guardian in the Leveson Inquiry. He served as the specialist legal advisor to the Parliamentary Joint Committee of the House of Lords and Commons, scrutinising the bill that became the Defamation Act 2013. And Andrew will start in a moment discussing general points on anonymity in civil proceedings and the relevant history of media regulation. Our second speaker then will be Caroline Addy on my left. Caroline is from Doughty Street Chambers. She's an able and experienced senior junior with a broad practice in all areas of media and information law. Caroline acts for both claimants and defendants of all kinds, from private individuals to corporations, NHS trusts, trade unions, police officers, website operators, and charities. She was the defendant's counsel in the first privacy action over a blog to be tried in England and Wales, a case called Sorrel, and she has particular experience of seeking and defending urgent injunction applications. Caroline provides pre-publication advice to major publishing houses, particularly in relation to contentious biographies and autobiographies, and to magazine publishers. And then our third speaker, Adam Wagner from Doughty Street Chambers as well. Adam is an experienced human rights and public lawyer with a very strong civil law background. He has acted at all levels, including in the Supreme Court and the European Court of Human Rights. He's acted in 6 public inquiries and is currently specialist advisor to the Joint Committee on Human Rights COVID-19 inquiry. Adam is well known for his human rights advocacy work. He founded both the multi-award-winning human rights charity Each Other and the acclaimed UK human rights blog. He's a sought-after legal commentator on social media at Adam Wagner 1 and on television and radio. And he set up and hosts the Better Human podcast. So we will ask the speakers in turn to speak, keeping to within roughly 10-minute slots. I will summarize once they've all spoken, and there'll then be some further discussion, followed by a Q&A session. And what we would really like for the Q&A session is not just questions, but also comments. We think that would be really interesting to see what people think about this really enlivening topic. So enough of me. Andrew, please.
First off, I want to say that it's rather daunting for a man of my antiquity to be addressing an audience to whom social media is really second nature. When I started at the bar, online harm would have been thought to be an aggravated consequence of railway trespass. But now, of course, it is at the center of political and social debate for a very wide variety of reasons. I can name just 4 by way of example. Radicalization, and I emphasize that the director of MI5 said the other week, that's as true of white supremacist organizations as it is of what we might otherwise call the usual suspects. Secondly, suicides and extreme distress caused by bullying. Thirdly, the racist abuse of footballers. And lastly, and not unimportantly, fake news, often generated by intermeddling foreign states. But that list also poses in a way a problem, because those matters are all headline catchers, whereas the gentler virtues of anonymity are not natural news leaders. I think the starting point is the rule we're taught in the cradle about statutory construction. The starting point is to look for the mischief. But in a case where freedom of expression is engaged, you also have to look at the virtues of the particular form of speech you're analyzing. And a good starting point is this statement by the United Nations rapporteur in his report to the Human Rights Council. He said this: throughout history, people's willingness to engage in debate on controversial subjects in the public sphere has always been linked to possibilities for doing so anonymously. The internet allows individuals to access information and to engage in public debate without having to reveal their identities. This feature is by no means unique to the internet age. In 1995, Mr. Justice Stevens, an American judge, observed in a case called McIntyre and Ohio Elections Commission, under our Constitution, anonymous pamphleteering is not a pernicious fraudulent practice, but an honorable tradition of advocacy and dissent. Anonymity is a shield from the tyranny of the majority. Think of the Arab Spring. Think of those who may be vulnerable within their own families or their own communities for reasons of sexuality or health, where sharing information is important to their well-being, albeit under a cloak of anonymity. It's not called Narcotics Anonymous for nothing. But the US courts have interestingly referred to the right to read anonymously. And this reflects the jurisprudence of the Article 10 of the European Convention, that freedom of expression means as much a right to receive information as a right to impart it. And one should also consider the places where anonymity is under siege. Take Russia. Since 2012, the Federal Service for Communications maintains a list to enable it to block URLs, domain names, and IP addresses. It was originally designed to prevent drug dealing, child pornography, and suicide-related material. But in 2014, it was deployed to block criticisms of government and local administration. In 2017, Russia banned all anonymizers and VPN networks which sought to criticize government. And in 2019, heavy fines were introduced. The remarkable thing about Mr. Navalny is that he does it by name. Very, very few people in Russia do that. And in 2020, the European Court of Human Rights ruled against Russia for blocking Garry Kasparov's website. In China, I shall mispronounce this, Sina Weibo or Weibo or Weibo, it may be Weibo, I suspect, a microblog platform had 500 million users in late 2018. They introduced real-life registration and immediately became subject to intense government interference. And bear in mind that Twitter and Facebook are blocked in China. I only mention these not to tilt the debate in one direction, but to just a caveat: be careful what you wish for. Now, what weapons does English law currently offer against the malign anonymous poster? Well, obviously the criminal law has terrorist and postal communications legislation directed at harmful content. But the problem is, of course, a prosecution requires an identifiable defendant. In civil proceedings, there's the Norwich Pharmacal jurisdiction designed to identify the anonymous wrongdoer, but it's slow and costly, and often it's unproductive, faced with Tor and Proton emails and all the other weapons available to the cloaked internet user. Section 5 of the Defamation Act 2013, if anybody has trouble getting to sleep, I recommend this provision. It's better than Mogadon. Makes the provision of information to a potential claimant about the identity of the poster of defamatory material a necessary precondition of a defense for website operators. But it's rarely used because Regulation 19 of the e-commerce regulations provides a better and less cumbersome defense. The law of harassment can be used against persons unknown and then served on the relevant address. That was done recently by Mr. Justice Siney in a case called Blackledge, where interestingly he said this: the facts of this case are a striking example of how the internet and social media can be used to abuse and damage innocent individuals with apparent immunity. Mr. Blackledge got his public vindication, but of course, no recourse in costs. Another area of development is the law of contempt. In the Angela Wrightson murder case, the first jury was discharged following prejudicial posts on social media attached to media Facebook pages and then shared. They reached both the witnesses and the defendants, and the divisional court ordered that the media should deactivate their comment columns on the trial coverage during the retrial. The Online Safety Bill has 130 sections, and you'll be glad to hear that I'm not even going to attempt to paraphrase it, save to say that it seeks to impose duties of care in relation to illegal content and children in particular on search services and user-to-user services, and it gives Ofcom a role in relation to codes of practice. But interestingly, Section 23 imposes a duty to protect freedom of expression and privacy of users within the law. And that highlights a core issue in our discussion. Does an anonymous social media user have a reasonable expectation of privacy in his or her identity in this jurisdiction? In a case called Author of Blog v. Times Newspapers, Sir David Eddy held that blogging was an essentially public activity and didn't give rise to any reasonable expectation of privacy. And one possible solution is requiring of the registration of a real identity behind your public anonymous identity, open to release if a court considers it necessary. Let me last just take 3 examples to show how difficult and layered this discussion is. My first concerns Mary Ann Evans, publicly known as George Eliot, whose novel Middlemarch was described by Virginia Woolf as one of the few English novels for grown-ups. It's commonly and wrongly assumed that she could only get a publisher by using a male pseudonym. That was not the reason. She did so for 3 reasons. Women were widely regarded as writers of only light romance, and she thought every man in the country isn't going to turn to page 1. Secondly, she was concerned that it would distract from her work as a critic. And thirdly, she didn't want scrutiny of her private life because she'd been living with a married man for 6 years before its publication. On the other hand, the Canadian Islamist feminist Ishad Manji said, "Anonymous is the one who's constantly threatening me with death." Last, I referred to the Arab Spring. Many were taken with the Gay Girl in Damascus blog, including many journalists. When it was reported that she'd been abducted, the US State Department launched an inquiry. It turned out to be a middle-aged American man living in Scotland. I should credit Professor Ash's excellent book on freedom of speech for these last 2 examples. I hope that set a general scene, but I'm now going to leave it to Caroline to speak against anonymity, and then Adam to speak for it. And I emphasize neither of them can be reasonably expected to take absolutist positions. Thank you very much.
Thank you, Andrew. It's worth, I think, reminding ourselves of the situation before internet use was widespread, which is possibly before 1 or 2 of you were even born. I think anonymous participation in any public discourse was actually quite rare, whether it was local politics, you went to the meeting or you wrote a letter to the local newspaper, which generally speaking wouldn't publish anonymous letters. They would want a name and address supplied at least to them. And attitudes to anonymity were generally negative. That's why we call anonymous letters poison pen letters, considered to be less than reliable, to be perhaps rather cynical and cowardly. And when we look at litigation, the procedure has always been very much that anonymity is exceptional and its use kept within very, very strict boundaries. Open justice is essential, and that requires knowing who people are. So as Lord Justice Toulson said in the Guardian News and Media against Westminster Magistrates case, who will guard the guards themselves? In a democracy where power depends on the consent of the people governed, the answer must lie in the transparency of the legal process. Open justice lets in the light and allows the public to scrutinize the workings of the law for better or for worse. So that included the limits on the situation in which parties could be anonymous as well as witnesses. And derogations from this have traditionally been pretty unusual and required strict justification. And the openness enables us to do two things: to understand the system generally, how it works and what our law is, but also to be able to scrutinize particular judges and or advocates even, and to police, if you like, their decisions and their behavior. And in media before the internet, the ability to keep a source anonymous has been subject to similar boundaries and rigorous justifications. And in both situations, I think the key element to enabling anonymity is that there is somebody, an intercessor, whether it's the legal representative or the journalist, who has effectively researched and considered the competing considerations and is in some way, by their professional expertise and standing, a guarantor for the authenticity or likely authenticity of the source. So if you think about the Watergate scandal uncovered by two Washington Post journalists, their secret source, Deep Throat, was for many readers worthy of consideration because those two experienced and reputable journalists considered that he was worthy of consideration and of reporting. The issue we have now is how to deal with a situation where anonymity is not exceptional, it's routine. And this is why the rise of the super injunction became very controversial. Was it going to become routine that in privacy litigation, particularly when we were talking about interim injunctions, the parties and even the existence of the order was going to be cloaked in secrecy? And the answer eventually came back no, which is why we have particular guidance and practice directions in the civil procedure rules, which set out very clearly the expectation that anonymity remains exceptional. The consequences of routine anonymity, I think, are paradoxical. It's what makes this subject so interesting and so difficult, because it may, and I'll come back to the may, allow, for example, brave dissent against oppressive regimes, but it also allows backlash against that sort of dissent and a distortion of whether or not the dissent or the countervailing view is the one that has the widest support. It enables many people who are incredibly vulnerable, marginalized, discriminated against, to find community online and to find support because they are anonymous. And at the same time, by doing that very thing, it can permit what are actually extreme and dangerous views or proclivities to become normalized, because online you consider that you are one of many, not one of a few. So it enables both truth-telling and lying. I don't think that means, however, that anonymity is neutral, not at all. Because for the great majority of internet users, there's often safety in numbers, you can attack, you can lie, and you can threaten effectively with impunity. And that has consequences that can't be cancelled out simply by someone else putting the contrary and correct view. First of all, I think the ability to pile on, to use the technical term, to things that you don't like, whether it's organized support bots or genuinely a large number of individuals saying what they think, generally speaking, can create a crisis, and that distorts all of our reactions to it. It means that in many cases, the cases that are prosecuted favor the high profile, where some kind of crisis has been created by the reaction. So that who is protected by our prosecuting authorities is not always consistent. It has another effect, which is that anonymity becomes a sort of contagion, because the worse our public discourse becomes, fueled by internet anonymity, the more people want to remain anonymous, and I would say often quite reasonably so. And a good example of this is the situation of the expert witness, especially in family cases, and especially in cases involving children, where they will give medical evidence about injuries and causation, or about psychological effects that might be at the very limits of medical knowledge, that might be controversial. And the source and the numbers of experts, as we are told, drying up. Because it is one thing to face cross-examination by experienced barristers acting within the rules of procedure and presided over by a judge, but it's quite another thing to face the campaigners and the activists from the various organizations that have made family proceedings so controversial. No one can protect you from the internet monstering, as it's often called, that you might have to face as a result of giving evidence. And the difficulty that we have is that once everyone is anonymous, then openness and transparency become impossible. And that has real consequences for our public discussion of just about anything. And I don't need to give you examples. I think you'll see any number of examples. Happens at the local level, whether it be controversy about planning applications, as is the case in my local newspaper week after week, happens at the national level in relation to much more contentious contemporary issues. And one of the results that we are seeing is that it does become very difficult to know what people truly think and where the majority is. And I do recall reading a report by one lobby journalist, who of course works on anonymous sources, politicians in the lobby, who said that it was his perception that the particular issue he was reporting on was in disfavor with most of the parliamentary party, but so afraid were they to speak openly that none of them actually knew that they were probably in the majority on that particular issue. We end up in our individual silos where nobody puts their name to particular positions. The other thing that I think happens, which is so dangerous for democracy, is that anonymity flattens all voices. We don't know who people really are. We can't assess their experience, their knowledge, their credibility, or their judgment, because they're all just names on a screen with no form of CV that we can actually assess or check ourselves. And it's perhaps not surprising then that most of what appears online is immediately and vociferously countered by others. There is no trust in the large avalanche of information we receive because we can't do that important assessment. Now we find that what occurs online has really become something that cuts across any number of protections, legal or otherwise, and delicate balancing acts that we have previously relied on in many respects in civic society. And its ability to do that, to undermine across so many areas, whether it be the dark web and selling drugs, or political discourse, or upsetting criminal trials by the dissemination of prejudicial information, is all fueled by the ability to remain anonymous. It won't have escaped your attention, I'm sure, that the effects of this are felt very unequally across society. If you're a woman, then the sort of threatening behavior and abuse to which you are subject online is of a different order of magnitude from that faced by men. And for every other protected characteristic you may have, that increases more and more and more. Whatever you think of her as a politician, I hope we could all agree that the sort of treatment meted out to Diane Abbott, who's one of our most dedicated constituency MPs, if nothing else, is absolutely disgraceful. And I don't know really how she carries on. So the consequences of this are grossly unequal. Um, we have very little really that we can do to counteract this. I think we all know that the resources of police and CPS are simply unequal to the task of dealing with this. It's really for us to decide what kind of cultural value we place on anonymous speech and whether the game's worth the candle. And I would say that the harmful consequences are such that we can't continue with the status quo. Only the rich or very well supported can really take this on by means of civil proceedings. As I've said, I think the criminal prosecutions are as much guided by what hits the headlines as what really is the most egregious case. But we have to decide as a society where we feel this ranks as a harm and what we're going to do about it. Thank you.
Caroline, thank you. Adam.
Thank you. Thank you for the speakers so far, for a lot of food for thought, which has had me scribbling down quite energetically. I want to start with Homer Simpson, who said of alcohol that it's both the cause of and the solution to all of life's problems. And we might think from reading the newspapers or reading the online commentary that social media at the moment is playing that role in at least in our collective consciousness, that it is both the cause of and the solution to all of life's problems. And I don't think that's right. I think that social media is very present in our existence and our public conversation at the moment, but it in many ways is the effect and not the cause. So for example, in relation to the issues that Caroline was discussing in particular, I mean, she said, I think exactly right, and I wrote it down, that the worst of our online discourse, the worse our online discourse becomes, the more people want to become anonymous. And that does seem like almost a vicious circle that we can't extract ourselves from, because something is making our online discourse seem like it's getting worse. And then more people want to become anonymous, but then the more people who become anonymous, the more people who can engage in abuse and that sort of thing. So I just want to try and disentangle some of that in what I'm going to say in support of anonymity, but also to make the point that this is all very new still. I mean, social media has been around at most really for 15 years, and in its current form, probably a lot less than that. And the difference between the world of social media and the world before social media is very stark. Before we had social media, if you wanted to have a public platform as an individual, you would either have to get yourself into a publication of some kind, or on TV or on radio, which for the vast majority of people was not an option, or you'd create your own pamphlet, which again, for the vast majority of people was not something they would do. And after social media, all of a sudden, we all have the ability to get in front of not just a few people, but if the wind is blowing in a particular direction, we could tomorrow be in front of millions of people. And often that is an experience that people may desire, but then realize they didn't actually want at all. But in that context, there are some important reasons why people want to become anonymous. I'll just pick up on 4. First of all, that they want to express themselves, but don't want their employers to see what they are expressing. And it's clear from the current debates that it's very easy to be misunderstood or judged harshly for opinions, which may even be very reasonable opinions, or may have been reasonable last week but are not reasonable now, or may have been reasonable, maybe objectively reasonable, but because something is happening in another part of society, that suddenly for a period they're not reasonable. So it's understandable why people might not want that to be in front of their employers. Civil servants cannot be seen to be politically biased or politically engaged at all in a party political sense publicly, but may want to express opinions. Whistleblowers very obviously would not necessarily want their employers to see what they're talking about until the right moment. Secondly, people may be afraid of government and other actors who may retaliate against them for expressing unpopular views or organizing protests. And in this jurisdiction, that may be less of an issue, but it's certainly a very big issue in other jurisdictions that we've already discussed, in Russia and China and other places, without as much protection from liberal democratic institutions. A third reason, people may have a different gender identity online than their gender identity in their life. They may be testing out a new gender identity, and that, quite as I understand it, it's quite often the case, and they would not want yet for people to know that. And a fourth reason, and again, this comes back to Caroline's, the vicious circle that Caroline identified, that for people who suffer online or indeed offline harassment or stalking, having an anonymous account can be an easy way to carry on engaging in social media without having to face torrents of abuse that define online harassment. And of course, you will all know about the secret barrister, who's written very eloquently about why they do not reveal their identity, so that they can be frank about the issues that they want to be frank about without colleagues being penalized or being thought differently of, that they can anonymize but still talk about their clients. And they serve a very important public good. I'm not the secret barrister, although I would say that, wouldn't I? Now, under human rights law, anonymity is one of those very unusual issues which makes friends of two rights which are usually very far apart. They're usually at loggerheads, which is the right to privacy under Article 8 and the right to freedom of expression under Article 10. But of course, both of those rights are what's known as qualified rights. So whilst they do protect, in the case of Article 8, the right to private and family life, home and correspondence, which has a particular meaning now in the debate we're having. And in Article 10, the right to freedom of expression, including holding opinions, receiving and imparting information, as Andrew pointed out. It's both receiving and imparting information. But those rights can be interfered with if proportionately and for a legitimate aim, for example, for the safety of others or various other reasons. And that's how the case law has played out. There have been various public statements on anonymity, and in fact, generally speaking, the public statements of international courts have been pro-anonymity, although the case law has been a bit more nuanced. So, for example, the Inter-American Commission on Human Rights recommended in 2013 that anonymous platforms should be promoted and the use of authentication services used proportionately. And they said the protection of anonymous speech is conducive to the participation of individuals in public debate, since by not revealing their identity, they can avoid being subject to unfair retaliation for the exercise of a fundamental right. The Council of Europe's Declaration on Freedom of Communication on the Internet, which is way back in 2003, said that member states should respect the will of users of the internet not to disclose their identity, but also said, importantly, this does not prevent member states from taking measures and cooperating in order to trace those responsible for criminal acts in accordance with national law and the various other protections. And Andrew already mentioned this, the UN Special Rapporteur report in 2015, but there it was said, encryption and anonymity enable the individuals to exercise their rights to freedom of opinion and expression in the digital age, and as such deserve strong protection. And one of the other things I noted in the report was it was said states must promote effective participation of a wide variety of civil society actors and minority groups in any debate relating to the adoption of restrictions on individual security online, and should avoid adopting such legislation under accelerated legislative procedures, which just brought to mind the fact that it appears that Labour at the moment are encouraging the government to accelerate the changes to the online harms bill to reduce protection for anonymity. There's been various cases which I'll very briefly touch on in the European Court of Human Rights. KU in Finland in 2008 was an important case, and the first case where the court explicitly dealt with the issue of anonymity online. An anonymous user of a dating site posted an advert on behalf of and without the consent of a 12-year-old who was, well, as she was 12 at the time, and a criminal investigation was launched, but failed because the dating site was protected under a Finnish law, which provided a right to confidentiality of telecommunications. The applicant complained of a violation of Article 8 and succeeded, and the court said the anonymity is not absolute and may be limited for the protection of other rights when prescribed by law and applied proportionately. And that very much fits with freedom of expression rights as well, which do not protect, and the court has said over and over again, do not protect certain kinds of hate speech, don't protect Holocaust denial, don't protect racist speech. Other cases of interest, editorial board of Pravoya, Dello and Shtetl and Ukraine, where the court acknowledged for the first time Article 10 of the convention imposes a positive obligation to create an appropriate regulatory framework to protect freedom of expression on the internet. And the case was about a media outlet that had been ordered to pay damages for republishing a defamatory anonymous text on its website. And there's lots of case law now, both here and in Strasbourg, about the principles to be applied when holding blogs or platforms responsible for anonymous comments which are posted on their sites. I won't talk about the other cases that I had because I want to wrap up. But just to finish off on practicalities. So my point really is that anonymity on a principle basis is important. But the second point is that on a practical basis, it's very, very difficult, if not impossible, to create a system which doesn't do more harm than good when you are laudably trying to protect people from some of the harms which Caroline identified. And just as a empirical point, it is unclear that anonymity in and of itself increases the potential for abuse. So there have been various studies on this. Halpin and Gibbs in 2013 suggested that anonymous users are more likely to engage in aggressive and anti-normative behaviors. But that assumption is increasingly being challenged. Recent research reported in the New Statesman found that social media users with anonymous accounts are only marginally more likely to send abusive messages to people in public life. And a new report from Privacy International suggests that some individuals may be less likely to engage in abusive behavior online when anonymized. There's actually little evidence to suggest that online abuse is necessarily affected by identification or anonymization. And in fact, it may be, to pick up that point from the beginning, it may be that it's a movable feast. It may be depending on the social media network and the way the algorithm works, that anonymity does or doesn't lead to people being more abusive. And just to finish off with a case study. So South Korea, which is, as we found out in the COVID pandemic, quite technologically far advanced from a lot of society, from this society, but and many other societies that we may look at. South Korea in 2004 adopted what was called the Internet Real Name System. And the point of that at the time was to prevent fraud in elections, but it quite quickly expanded into other areas. And interestingly, very similar justifications to the example, the Russia example, which Andrew highlighted, because there were investigators linked several suicides to cyberbullying and online slander, which led to a public conversation about it, and then an expansion of the real name system to major internet providers. And what happened to that was, well, first of all, in 2011, there was a data leak a data hack, and 35 million people's details were hacked from the system. So you've got to think very carefully about who is holding all this data. Can we trust the internet providers not to sell it or lose it in a hack? That's one point. And then in August 2012, the Korean Constitutional Court unanimously voted that this law violated the constitution. And it said, I'm not going to say it in its original Korean, but I can guarantee this is my translation and it is accurate. The system does not seem to have been beneficial to the public. Despite the enforcement of the system, the number of illegal or malicious postings online has not decreased. Instead, users moved to foreign websites and the system became discriminatory against domestic operators. It also prevented foreigners who didn't have a resident registration number here from expressing their opinions online. So I finish exactly where Andrew finished. Be careful what you wish for.
Ladies and gentlemen, if we don't all say we're not the secret barrister, it doesn't mean we are. Now, that's all been very interesting. Because you're all very good barristers, of course, my mind has flipped backwards and forwards as you've been speaking. Andrew, let me start with you. You pointed to very good examples of circumstances where anonymity is a good thing. You mentioned the Arab Spring, for example. You mentioned the case of Russia, China. One thing I was very interested in was your reference to the online safety bill. I just wonder, you went on to say there is perhaps some prospect of requiring people who have to enter their identity, of providing a real identity, and they can then, by all means, blog or whatever it is anonymously. But if there is a reason for investigation, at least it can be found out who they are. Is that, Andrew, something that is proposed to move forwards? Is it practical?
It's not in the bill. My recollection is it's been proposed by Margaret Hodge and has been the subject of some discussion. In the last discussion I heard, it was the person debating it with her said that there were problems with it, but then didn't say what the problems were. But it's certainly an interesting notion of a two-stage. You have an anonymous public persona, but the court you have to have a real life identifying feature underneath, and the court can order its disclosure in an appropriate case. I find it quite an attractive compromise, but there may be other difficulties with it, I suspect.
And what struck me was that it would be impossible to legislate in a way that tried to fit all sizes, because you do have lots and lots of different sets of circumstances. Whistleblowers, yeah, it would be difficult to invent a law that cut those down for very obvious reasons. There are lots of beneficial aspects to anonymity, but I think I agree with Caroline that there are many other aspects which are really quite awful. I agree with the point you made, Caroline, that allowing people to behave unethically behind a veil may well increase the potential for severe abuse. And I was kind of interested to hear you referring to the research. Adam suggested that might not be so. I'm a bit skeptical about that. But still, if you don't approach this as a one-size-fits-all problem, I mean, one can't legislate for China. We can only look at our domestic scene and then pick off areas. One can quite see that one area, perhaps you wouldn't interfere with anonymity, but others, TripAdvisor, what possible reason is there for people being allowed to bring down a little guest house on the South Coast? Perhaps because there are a rival guest house up the road. You know, things like that strike me as being quite obviously wrong. So perhaps our thoughts might tend in their direction. Anyway, enough from me. Comments to add from all three of you.
One thing I would add is that the more we enable and expect anonymity, the more we will find it used in ways we don't like or haven't expected. The oppressors also use anonymity, and there's a recent decision, the European Court, I think, about Article 6 rights in Russia, where there was a trial of politically motivated, I'm sure, against a dissident in which all the prosecution witnesses were anonymous, and they were not even, their identities were not even known to the judge, and the potential for misconduct in that kind of situation is absolutely obvious. But we enable those sorts of situations more, don't we, if we accept that our public discourse has become irredeemably difficult, controversial, vengeful. And let's not forget, there are real life consequences, doxing, swatting, all this sort of thing that do happen to people as a result of what they say online. But the more we, if you like, concede that anonymity is necessary, the greater may be its unfortunate uses, including by the powerful. And even the ability to dissent in anti-democratic regimes is under threat because the technology marches on. As we've been finding out in all sorts of different ways, including in our own family court, governments and government actors have the ability to discover identities and to conduct surveillance far beyond what we may have understood even since Edward Snowden.
I found it interesting when you were talking, Adam, about employees who might want to express themselves in a safe way. And so long as you objectify the discussion and talk about other people, it all sounds reasonable. If you bring it closer to home by thinking, how would this play in my chambers if people were able to leave typed notes saying, I don't agree with the temperature at which you set the air conditioning, it's a complete disgrace, we would be unhappy. We have very open discussion in chambers, nothing is ever anonymized, and that's the way I like leading our lives. I really wouldn't like it if there were anonymity brought into our little group in chambers. It's only when you look at other groups that you think, well, yes, maybe that seems reasonable. Well, what do you think, Adam?
Well, I've got a very direct experience of that because that almost exact thing happened to me. I found out that an anonymous account, which was quite abusive, was very abusive towards me on Twitter, was being run by a Chambers colleague. So precisely that example, who then resigned from Chambers. But that, you know, that to me, you know, was a very, very extreme example. But, you know, it did bring home to me the importance of, well, first of all, you know, arguing against my own position and arguing I think I agree. I'm dubious of the research which says that people don't behave worse if they have anonymous. I think actually it depends on the individual, and I think some people will. It depends on the individual where, you know, the difference between someone who, say, is a professional who may have professional disciplinary concerns about expressing, you know, about behaving in a certain way versus other people for whom the consequences might be, you know, might not be as bad, or maybe even they may be praised for laying into somebody on social media in their circle. So I think it depends on the individual, but yeah, that I was very relieved when that anonymous account was exposed, and it was nothing to do with me. It was completely random that it was exposed. Through you know, and I was told about it. You know, 11 o'clock at night, somebody messaged me and said, "Have you seen this? Isn't this person in your chambers?" And so I said, but it's I've thought about that quite a lot, and about the implications for the wider discussion, as you say. And I think, first of all, it's a big risk to extrapolate out from extreme examples to the wider picture, because I think anonymity does, in many cases, serve a really important point. And that example, in my view, was very clear and straightforward. But I was going to quote from Handicide in the UK, which is the famous case about the right to offend, and I will do. The right to freedom of expression is applicable not only to information or ideas that are favorably received or regarded as inoffensive or as a matter of indifference, but also to those that offend, shock, or disturb the state or any sector of the population. Such are the demands of that pluralism, tolerance, and broad-mindedness, without which there is no democratic society. And I found a much pithier version of that from Gloria Steinem, which is, the truth will set you free, but first it will piss you off. And I think that the importance of both those quotes is you've got to be very careful who is the arbiter of what crosses a line into unacceptable speech, because generally speech and public debate and about issues that people care about is can be very offensive and very difficult and very, excruciating. But it doesn't mean that it's bad speech, and it can actually mean that it's very important speech. And one of the things that social media has done is given us access to the widest possible range of views. So I'm, on the positive side for anonymity, it's very important to maintain as much as possible the fierceness of those public debates and the difficulties and the offensiveness, because that's where free speech really resides. But I entirely see, and from a very personal perspective, and can entirely see the opposite argument.
So thinking even further about personalizing this, and I hope this doesn't bring down a storm of abuse on my head anonymously, but say somebody went online behind a secret account and described my chambers as providing the most awful service in the world. There could be no possible reason for not requiring that person to put his name to his insult, could there? I mean, could there? I hope you all agree on that. And I don't know how practical it would be to bring in a law making it impossible for people to shield themselves if they're going to engage in that sort of behavior. I mean, you could legislate domestically, I suppose, but you couldn't, a lot of these media companies will have their homes in the States, and I suppose you couldn't really do anything about those. Andrew, is that something you've come across in your world, about the practicalities of trying to shut down overseas organizations?
I mean, there's a bigger point here. I mean, my own view is that this discussion sometimes I emphasize that was a microphone, that this focuses the critical question often is remedies. And we have for a long time focused on takedown, and I think not enough on prevent. Children, to my mind, are actually the biggest concern of all. I think I'm right in saying that over 95% of children aged 15 have access to social media. And the adverse effects we're talking about are instantaneous. The distress caused by bullying, the anorexia, the suicide, all this kind of material, quite apart from unsuitable material, is instantaneous, and takedown is far too slow and simply not the remedy we have to look for. And it does seem to me that some form of prevention, and that must, as usual, be a mixture of deterrent by some actions by the state in appropriate circumstances, and by imposing on the companies, in the sense used in the Online Safety Act, really quite stringent requirements, is the way forward. But technology is constantly moving, and it's very, very difficult to keep up, particularly bearing in mind that there are other countries who have very different priorities. But I do think if any debate should start with children, frankly.
We haven't talked about money yet, which we probably should.
Caroline, who definitely needs to talk about money?
In the sense that there is money in vitriol, and the more extreme, the more hard hitting. There's been a suggestion bandied around recently about anti-vaxxer propaganda, which is that there are only about 12 persons or entities behind the vast majority of the anti-vaccination propaganda pumped out, certainly in the US. And all of the individuals among those 12, and probably all of the 12, have a significant profit motive to circulating that information. It doesn't feel as though it's only 12 entities. It feels impossible because they are so successful at pushing it out through different outlets. And one of them is a member of the Kennedy family who has had a very lucrative career as a trial lawyer, taking on pharmaceutical companies. I don't criticize that in the least, but there is an overlap between the campaigns against vaccinations and what he does for a living. which ought at all times to be transparent, to be something that we can see. And it shouldn't be the case that information is ever sort of percolated through hidden springs, to paraphrase a famous defamation judgment. But there's another aspect to money, which is that we all take for granted that we can broadcast to the world and participate in all of these discussions for free. And it's accessible to everyone. As long as you've got a device, and most of us have a smartphone, that you don't pay anything. And if we want safeguards, and if we want real-time moderation, and if we want prevention, are we prepared to pay for it? Because I can quite see that many of the technology giants might say it will take armies and armies of people and ever more sophisticated algorithms, and we're going to charge you for that. It's back to be careful what you wish for.
Yes. And now I should just interject a point of information. We are due to finish this at 7:25, not 7:30, and we've got some Q&A coming up. I'd quite like to start that a little early, because I think there will be quite a lot of questions and comments, and I think we'd all value discussing them up here on the platform. The first question I've got, they're rolling in, so please do participate. The first one is from an anonymous attendee. And I'm not sure I understand all of it, so I won't read that one out. For any other contributor, you have named yourselves, but I won't name you, just in case there's something slightly sensitive. So don't worry about identifying yourselves. I won't mention your names. Let me just mention the first one. And this is a very good point, which nicely illustrates the difficulty in this area. Here it is. With regards to having open dialogue in a workplace where people can discuss complaints or issues, what would you say about situations where a colleague or a subordinate felt unsafe or unable to bring up an issue under their own name for fear of professional consequences? For example, allegations of sexual harassment or gender-based discrimination in hiring or pay scale. Very good question. I mean, in a perfect world, there wouldn't be a problem with that. But we're not in a perfect world. People are in organizations where consequences do follow from complaints that aren't anonymized. So how do we deal with that, Caroline?
I think, especially in relation to things like sexual harassment, we've always recognized, haven't we, that if you're a person in a situation of power imbalance, wanting to make a complaint, to make changes, that it's probably acceptable for you to have what I'd call qualified anonymity, so that you'll be anonymous perhaps to most, but not necessarily all of the people in your organization. So we avoid the sort of Russian trial effect where nobody knows who you are, because that's pernicious and difficult for obvious reasons. But it seems to me perfectly legitimate that that person should have anonymity so far as most of the organization is concerned, and certainly for most of the time. But there are, as Andrew said, there are no absolutes. And if you're going to avoid manipulation and misuse of a process, then there will always be situations, however unlikely, where you may have to bring someone's anonymity to an end.
Yes. I suppose the dimension that you simply can't explore if it's anonymous concerns factors associated with the identity of the complainant, which may be very relevant to the complaint. And you add to that the fact that it's very, very troubling for an organization to have an anonymous complaint. I mean, it makes you feel uncertain, uneasy, troubled. So there are always two sides to this, aren't there? Anything to add, Adam, from you?
No, not to that.
Let me go to the next. Here's a goodie. Should Twitter be a platform for free space or be curated? We touched on this.
Well, this is a huge issue. I mean, the question of whether they should be treated as publishers of the content they carry, or whether they are merely platforms as the position which they would like to take, is a fundamental question which underlines a whole lot of various torts. I mean, at the moment, they have a lot of privileged defences in defamation and in other areas where once on notice, they generally do have an obligation to take down subject to certain conditions, but they have absolutely no obligation to pre-moderate. There are huge issues of resource here. There are issues of policy about whether it would chill debate unduly. Facebook claimed to have 44,000 people already engaged on trying to identify harmful content. All I can say is, if you look at their profits, I might think that they could employ a few more. But this is a fundamental question about which direction the law should take, as to whether they should be treated as primary publishers of the material they carry or not. I think there are problems with making them primary publishers across the board, but equally, simply treating them as people who have to merely take down on notice seems to me to be too light touch.
If I could add to that, I mean, look, I'm all for a platform like Twitter staying as free as it can be, and for conversations to still be available for people, because it brings a lot of good, and some of the conversations are wonderful and funny and interesting and engaging and entertaining and all of that. But I think it's becoming more and more absurd to separate Twitter from a broadcaster, for this reason. If you look at the way a broadcaster works, a broadcaster has editors and producers whose essential job is to find the most popular programs, the most popular content that they can put on, get as many views as possible, and then sell bits in between the program to advertisers, because on the basis they're getting lots of views. And Twitter works by hiving that job off effectively to an algorithm to find the most entertaining or extreme or attention-grabbing content, so that it can go to advertisers and say, look at these amazing engagement figures, look at these amazing, the numbers of people who are addicted to this platform or are going on 20 times an hour just to see, which of their favorite tweeters is having a fight with which of their their least favorite tweeters today, and in what ridiculous thing has been said, and what are people getting very, very energized about this hour. And that is very attractive to advertisers, because advertisers want people's attention as much as they do on TV. So for me, just the difference between the platforms, well, first of all, is that it's an algorithm versus human editors. But the algorithm is designed by somebody, by a human, and quite obviously to get more attention, and that's why the discourse becomes more and more extreme and more pissing off, as Gloria Steinman said. So I just think that at the moment they're having the cake and eating it. They are acting just like a broadcaster selling advertising to people's and engaging people as much as they possibly can. But at the same time, they have seemingly no liability, or very little liability, for what their algorithms are promoting. So I think it's in some sense unsustainable, but I'm not saying that they should be responsible for every idiot thing which is said on the platform, without any more scrutiny, without any more structural. Sorry, put it another way. Without any more, so without some sort of pre-notification or some sort of rules for what they'll be responsible for, because obviously people are filterlessly expressing themselves, so it's different to TV or radio. But I do think there's an argument for regulation more than there is now.
Now, thanks, Adam. Here's a heavyweight question. Is it not hypocritical to support anonymized accounts on social media in authoritarian nations like Russia and nations during the Arab Spring, yet looking to stifle the same anonymized accounts on social media in nations like the UK? And the speaker adds, I asked this question while using Home Secretary Priti Patel's decision to look for banning anonymous accounts on websites such as Twitter following the stabbing of Sir David Amess. Any comments on that?
Well, it's interesting that Guido Fawkes's anonymity lasted here 5 months before the Guardian managed to expose him. I mean, it is quite difficult here to be a political blogger, I emphasize, of influence without being detected. I do think political speech is in a special category myself, and I think it's dangerous to allow it to stray too much into some of the other harmful areas. The European Court tends to divide speech into different kinds, and it's quite helpful to do so to make sure you don't throw the baby out with the bathwater.
Here's another. In the opinion, would compromise, including, sorry, it's just disappeared, including forms of extra payment for extra protection against anonymized abuse online, be acceptable? Example, in a social media context, if Twitter and the likes offered up additional adverts to fund extra staff to hunt down trolls. Interesting context to that. I heard today on the radio that Facebook have 40,000 staff whose job it is to engage in this area. 40,000, that's how seriously they take their profit motive, I suppose. What do you think about that? I'm sure they're working on this already, but it's plainly a way to go. Although hunting down trolls, I imagine there's quite an easy solution to that, namely to refuse to accept anything unless people have to provide identity in the first place. Any follow-up to that?
Well, I mean, is it 40,000 people is a drop in the ocean for Facebook that made, I think, $8 billion last year in profits. So I'm not too worried. Well, first of all, I'm not too worried about this making a dent in the social media companies' profitability. But also, I don't think there is any prospect of social media companies making people suffer either by paying or seeing more adverts to make them safer, because I don't think social media companies will want to accept the premise that people are unsafe or at risk on social media. I think it'd be too damaging for them for that narrative to exist. That's why one of the things that Facebook say over and over again is, we want you to regulate us. And I think the reason they say, and they say that to governments, and I think the reason they say that from a public relations perspective is because then they can blame the governments when the experience becomes less less enjoyable for individuals as they see it. And I think that's a very important sort of public relations exercise for them. So I just don't think I don't think people will end up paying a safety premium. I think we are all, and I put it another way, I think we are all paying right now. I think it's wrong to think that social media is free. We are selling ourselves to advertisers and social media companies. We're selling our opinions, but we're selling them without all we're getting back is access to the platform. So I think that's the way to look at it, is the commodity is our views and our expression of our opinions, and we are being and the exchange is free access to the platforms, and the abuse we get, which you may think is not a great fair exchange.
Two small, completely unrelated points. The first is Ofcom's Code of Practice, assuming this bill becomes law, will be a very interesting document. Secondly, we're very much focused on the legal issues. It seems to me that education is a profoundly important element in all of this. I don't think online responsibility at the moment is a compulsory subject, but it certainly should be.
Well, it's certainly taught in primary schools.
It's certainly taught. I've asked one of my grandchildren this and was told that he is taught it.
Well, my children were taught it, and of course, having a mother who's a media barrister, they got additional sessions, which were so successful that they now don't allow anyone to take photographs of them and complain if the school wants to put anything on the website. So it's become rather unmanageable.
The hockey team full of black and faces on it.
But they do also demand to know my online identities. So I do feel something of a hypocrite because I jealously guard my Reddit avatar and my mum's net username and all the other things from my children, much to their annoyance.
Now, we've been neglecting our studio audience. So are there any questions out there before we go back to the online questions? I can see I think I can see a hand up. Sorry, we got light shining brightly at us.
Hello. Oh, I worry slightly that the question of this debate is a bit misleading. I'm not sure that true anonymity often exists on social media platforms. They know the location you created the account in, they know the email you used, etc., etc. So I wonder if, especially those on the panel in favor of anonymity, how would they answer the question, who would they rather trust with their information, these social media companies interested in making money, or the government who has a vested interest in popular interest?
Who's going to answer that?
Well, as the person who ostensibly is for anonymity, I think it's a really good point. I don't think, there's lots of different kinds of anonymity, and we've been quite vague, we've been quite indistinct in the way we've discussed it. But there is anonymity, there's pseudonymity, where people are, speaking from an institutional account, or from something which looks institutional but isn't. And you're absolutely right. There's still lots of ways that if the police want to find you, they can find you, whether through your IP address or through the email you used to set up the account, or your mobile, or that sort of thing. But who would you trust? Well, I mean, one of the absolute, lessons of history is that we should be skeptical of authorities having holding too much information about us. And I use that word skeptical because I think it's overstates to say we shouldn't allow authorities, because you can't trust authorities. Because I think in a liberal democracy, you can, by and large, trust authorities. But the point you made about, well, what happens when you become unpopular, I think is really important. And if you are either a group part of a group which suffers particular degradation in society, either at a given time or historically, or you are part of an unpopular cause, which is important but unpopular, which quite often causes are important but unpopular, then you don't want to be you want to be protected from authorities going too far. So I think it's really, really tough. And so we should be skeptical, I guess, is my answer.
Well, I mean, I think I would just add to that the power and reach of the largest social media companies is such that we need nation states to hold them in some form of balance. Only governments can do it, and that's why considered legislation is so important. Because if you look at the protection of rights at the individual level, it is extremely difficult to do. Litigation is too expensive for many, or they simply wouldn't know where to start. We do urgently need governments to provide some sort of counterweight to what's otherwise a kind of supranational impunity by the tech companies, I think.
It is worth observing that the number 10 Christmas list, invitation list, is no longer to newspaper editors, but to the media directors of the big platforms. They're the people the politicians want to entertain these days. It's worth bearing in mind.
Now, here's another question that raises the practical problem that we've been skating around really all evening. What are your opinions on requiring an identity verification in order to create a social media account? For example, something along the lines of what's required for verified public figure accounts. Now, I think, Andrew, when you brushed on this in your talk at the beginning, you had in mind, I think, some sort of body that would consider complaints. Because if there is anonymity, but a real person behind them whose details are held by the body putting out the tweet or the blog or whatever it might be, in order for people who complain that they're being victimized or that the complaint that's being made anonymously is untrue, they'd have to go to somebody to require the identity to be revealed. And I wonder how that would work in practice. Has any thought been devoted to that, do you know?
I think almost none, and I'm sure the courts would not welcome an absolute deluge of this sort of work. One of the problems with it, it does require quite a lot of technical understanding as to what is actually possible in the context of the particular account being used. As people probably know, a lot of the offshore United States ISPs are very difficult to get any order against. Some states will give them, but others will not. And the question, I think, is always going to be what is technically possible, first of all. But I think it should be an order from some body or tribunal which has an ability to look at the facts. One of the other problems is that by definition, the party seeking anonymity is not going to be heard. So there are going to be all the problems which attach to ex parte hearings, where you only have one side of the argument. And that in itself can pose difficulties.
Addy, thank you. Now, I have to read this out because this is a repeat of the very first question we had, and this chap has considerable staying power. The repeat of the question is this. Adam mentioned the studies suggesting little difference between anonymous and identifiable social media users and levels of online abuse. I think he said that this abuse was directed towards people in public life, i.e. celebrities. Are there similar studies looking at online abuse directed at the general public? Adam, do you happen to know?
I don't, I'm afraid. I'm not even sure. I'm not even sure I did say it was celebrities. I think it was just. I'll tell you where the report is, so you can look it up yourself. I think it was Privacy International was the report.
Thank you very much indeed.
Lost it now. Yes,
so I'm sorry to disappoint that questioner, but we do have questions from the studio audience. We're going to have to wrap up very shortly. Yes.
I think that something that's really interesting that was picked up by Andrew is the need for education, because I think that the most important people in society at the moment are children. And so I think perhaps, or at least Caroline, my position on why public discourse is not great at the moment is a lack of nuance. And so I wonder whether to address both sides of the argument, perhaps encourage discussion and remove the need for anonymity so much on social media could be an introduction of education schemes for children that encourage debate, or, you know, and what flows from that are things like compassion and understanding. So do you think an introduction of something like that into the curriculum could address the social harm that can come from anonymity? And if you think that's necessary, who do you think should fit the bill? Should it be the government or some sort of encouragement of a contribution from these social media companies?
Well, I think that's a good question. I think that a lot of it is happening, as we say, not just in primary school, actually, because PSHE, Personal, Social and Health Education, is covering it, how to keep yourself safe online, but also, I mean, there's a very strong strand in education at the moment, the anti-bullying weeks and that kind of thing that people have, and dealing with people's feelings, which is very often mocked and excoriated, even in the mainstream media, as creating snowflakes and things like that. So there is a very strong understanding from what I see in my own children of the harm that words can do, and the necessity of, if you like, playing the ball, not the man in discussions. And I think that can only help. And in fact, the one form of regulation we haven't talked about tonight is self-regulation, is self-restraint. I mean, for anyone who's, you know, especially for us working in media before social media and the internet became a commonplace, there is an element of confusion and discombobulation. Like, you know, when did we become a country in which people routinely issue death threats to people in public life that they don't like? Because I mean, I can remember a time when perhaps this sort of thing that just didn't happen. And we have, or some of us have given ourselves license to do that. And it's actually very important that through education, we take that license away and once again decide then that is not something that any reasonable person should do. So I think that's an important part of mainstream education. I've always thought that we should teach a lot more about civics and elections and that sort of thing, and I think it falls into that. Speaking for myself, I would not like to see the social media companies anywhere near it. They're two-party pre. I can just imagine the sort of flashy but ultimately empty presentations to which children would be subjected. And in the end, their profit motive is too tangled up in a lot of the practices that are problematic for them really to be able to do this. So I think it's a mainstream education issue and also an issue within families.
Adam, you wanted to add?
Just briefly, I thought it was a brilliant point to end with. I think education and also culture are at the heart of all of this. Really, anonymity, in a sense, is a symptom, not a cause, although it can be a cause. And I think that the social media is so new, and this ability to express ourselves publicly without any filters is so new that we're still catching up, developing the values and the language to explain. You know, the idea of a pylon is how old is the idea of a pylon? 3-4 years? You know, just this, even just describing the behavior is the start. And I think that whole new civic language that's developing needs to be really heavily pushed, not just for children. I think children have their own slightly different issues because of the way that children socialize is quite different to the way adults socialize online. But I think adults really need a big, dose of civic education. How that will be disseminated, I really don't know. But I do agree with Caroline that it's not going to be from the social media platforms if we want it done properly. It's probably from people who influence public debates and you know, as they usually do, just getting out and changing the culture.
Where is Mary Whitehouse when you need her?
Where is Mary Whitehouse?
Well, ladies and gentlemen, I'm so sorry to disappoint those who, there are stacks of you online who've got questions that I'm afraid are going to go unanswered, and some here in Temple Church too, that we haven't been able to get round to. We've hit our time, I'm afraid. I came here this evening with pretty fixed and firm views about what we were going to be talking about. I chose this topic. I think it's fascinating. And I must say, this evening has made me think that it's actually a whole lot more nuanced and difficult. So I've come away much less certain, which is not the way I wanted to be, but it's probably a good thing. Thank you for your interest. And can you kindly thank our speakers who've given up their time to come here this evening? And a lot of work has gone into this, as you can see. Thank you very much indeed, Andrew, Caroline, and Matt.
Mm-hmm.